Can I now welcome Ms Murdoch as representative of Dispute Management Australia. To assist Hansard to attribute your words correctly, I'll ask you to please state your full name and the capacity in which you appear today.
Sure. My full name is Tania Murdoch, and I'm here representing as a family dispute resolution practitioner accredited and an accredited mediator, a behavioural healthcare family educator, and also I am, my company is Dispute Management Australia.
You've lodged a submission with the committee. Are there any amendments or additions to that submission?
Yes. I would like to contribute a little bit additional information today,
So
if I could.
In a moment, yes.
Sure.
And information on parliamentary privilege and the protection of witnesses and giving evidence has been provided to you as part of your invitation to appear. So can I now invite you to make some opening comments?
Absolutely. Thank you. Thank you very much for having me here today. I think this is of the utmost importance to our society generally, because I believe the way we treat families in our environment is so important, and it affects things such as high chronic stress levels and related domestic violence disputes. And I'd like to speak a little bit more about that as we go along. If I could just make a general opening statement. I work within the family law context and as an accredited family dispute resolution practitioner, mediator. So I work with a lot of family lawyers, and I have a high regard for the profession and a lot of respect for the people that I do work with. I do work with the Queensland Law Society also as an educator, and I am on the Wellbeing Committee, so in the attempts to actually improve the wellbeing of family practitioners. Good counsel is about fairness and justice. However, law is fundamentally a win-loss game, an adversarial game. This is still deeply entrenched within the profession. The adversarial process lies at the heart of that system. One side wins, one side loses. However, there is a psychological cost to being anger stances in our society at the moment, and is affected by perpetrators of domestic violence, and some of them of which we have failed miserably. And then on the other hand, we have people that are actually using the system, mocking the system deliberately to suggest that people are committing domestic violence to avoid their societal obligations as per the Family Law Act with regard to mediation, for example. And they're deliberately using these means to manipulate the system. So I think that we need to increase awareness and actually really get on top of this. It's a really important topic. And one of my concerns is the Family Law Practitioner Association, for example, that was calling in earlier, which was very frustrating that we couldn't hear them. I'm wondering if a person such as me, independently, can fly up to Townsville last night, speak here today, and then fly back down, miss my normal day's work, obviously personally pay for the accommodation, etc., to get up here. I find that this is that important to do that. Now, a membership organisation, of which I am a member, by the way, that is getting contributions by their members, why can their representative not be here? I think representatives need to be here in person, listening over the phone, that cutting in and out and in and out. How can you make the important decisions that you need to make? And this is what frustrates me, because this is affecting our society so much. And at the end of the day, all these families are under such chronic stress for such prolonged periods. What do you think is happening to their children? Clearly, their children are going to be adversely affected. There's loads and loads and loads of research on this, and this is where we need to start making some changes. I would just like to simplify what I think is somewhat a mathematical equation. So we look at ongoing high conflict, disproportionate legal fees, high legal fees, the adversarial process, extensive delays, which also include family relationship centres, which I've worked both Relationships Australia and Centrecare on the Gold Coast. Anything that exacerbates conflict between the parties, domestic violence, false evidence, manipulation of the legal system, All of these things equal nothing less than harm to children and families. So I support the improvement, any mechanisms to improve the timely, the efficient and the effective resolution. If I could just mention the difference between dispute resolution and mediation, because as I mentioned, I am an accredited family dispute resolution practitioner and an accredited mediator, which are separate things, but they both involve mediation. The Queensland Law Society and the Law Council of both support timely, efficient and effective dispute resolution. Dispute resolution can be called, from a legal perspective, just the legal process, dispute resolution. I'd just like to differentiate mediation and dispute resolution, because lawyers often refer to dispute resolution as their process. So, as you heard earlier, mediation, the settlement in mediation is very high. Now, this isn't just in families, this is across the board. This is internationally, this is not just in Australia. So the Queensland Attorney General's Department, a few years ago, I attended a breakfast, this is in Queensland, relating to the high positive outcomes, settlement outcomes for mediation, just within the general business community. I'm also a workplace mediator, franchising mediator, and I mediated a general dispute for some parties in a development project. Obviously, it was financially motivated, and they had been working with their lawyers for, I think, approximately 7 to 8 months. Independently had spent about $20,000 each, just in that short period. They came to me with mediation. They paid approximately less than $1,000 per party to do, I think it was like a 4 or 5 hour mediation, which we finished early. The mediation had a 100% success rate, and they said to me that this is a commercial mediation. However, family mediation is very similar. A lot of the problem in family mediation is that people don't know how beneficial mediation is. People are not steered down that avenue for various reasons, which I have mentioned in my submission as well. But just the example that things can be resolved so quickly, so efficiently, it's kind of like, I don't understand where we're missing the point here, because dispute resolution is not about adversarial conflict. Dispute resolution is about meeting each other's needs to the best possible way we can. And obviously, we're not going to meet 100% of each other's needs, but mediation actually attempts to achieve the best possible outcome, rather than deliberately, as soon as you get a lawyer's letter, I'm not sure if you're aware of this, but your heart rate increases because you're reading this letter. If you know that this is about you, I mean, what's happening already? And nothing's even started yet. And I'd just like to differentiate as well, because James Steele, I think, mentioned that most cases don't go through the process of court. Well, that's the case at the end, but they do go through 2 to 3 years prior to that. So the process they do actually go through. You can refer to it as the court process, the dispute resolution process, whichever way. But the fact that people are fighting adversarially is where the problem is. And if that goes on for a period of time, obviously the longer the period, the higher the conflict. So the more aggressive the solicitors, the more adversarial the case becomes, in my experience anyhow. So I've watched a lot of these cases. So with regard to domestic violence, these children are living in these homes. The people are chronically stressed, even if the parents don't act out like adversely. The children are picking up on the chronic stress. And the problem is, when we're under chronic stress, and this actually occurs for lawyers as well. I do a lot of training in vicarious trauma for lawyers. What happens when we're under chronic stress, unrelenting? Our executive areas of our brain go offline. We go back to our primal primitive processes where we fight, flight or freeze. Now, these children are experiencing parents for prolonged periods under fight, flight or freeze. How do you think the children are actually being affected by that? And then we ask the question, why is there so much domestic violence? Why are people so angry? children are being grown up in these environments where people are hostile or angry or affected in one way or another, and we're failing them. You know, this is very dear to me. I just find it. I have 3 children of my own, and I would just hate for them to have to experience the levels of some of the things that I've seen through mediation. And you know, in some occurrences, there is definitely a bias because I've had clients, both men and women, that are affected by domestic violence, fairly significant levels. And, you know, I had a guy that was really on the edge. He was losing his, you know, he felt like he was losing his mind, which is executive functioning, offline big time. And he was being affected by domestic violence. He went to the police and they kind of made a joke of him because he's obviously a guy. And then they said, well, no evidence, mate, so sorry. So he walked away. He was distressed. He's ringing me. He said, I'm trying to get into mediation with the family relationship centres. They said, I've got a 4-month waiting list. He said, I'm ready to commit suicide. I saw him within the day or next day or something like that. When I saw him, he was beside himself, so I had to calm him down quite a lot. Then he did actually manage to pick up some video footage of what was happening. And he showed me the video footage where she was attacking him with a chair, and he was cowering in the corner. And he was terrified to take that video footage because he knew if she found out, she would go crazy. So it happens on both sides. And the thing is, we need to really identify. A lot of the problem is the Family Law Council, I noticed in their submission, they highlighted that you all, as committee members, should do training in domestic violence awareness. I 100% agree. I think everyone should, actually, in our society. But interestingly enough, I'm well aware that there's a lot of lawyers that haven't had any specialised training awareness in domestic violence. So I'm thinking we need to up the, you know, the situation there.
Ms Murdoch, do you mind? I might interrupt because
Absolutely.
we'll run out of time to ask questions.
Absolutely.
So you may be able to pick up some other things that you were going to say in terms of your questions. But it does lead me to a question which you may have heard me put to a previous witness, and that is, particularly in relation to parenting, is the adversarial system the wrong approach because it seems to set people up against each other in conflict from the very outset when, at least with parenting, we're trying to find a resolution which is in the best interests of the child and hopefully, ideally, one in which both parents can continue, except in exceptional circumstances, I accept where they can have some continuing involvement in the life of that child. So do we need a new approach?
I could probably say, from my perspective, 100% sure that the current adversarial system is not working. It's failing. However, mediation obviously is achieving good outcomes. Arbitration is coming on board, but that's still got adversarial sort of nature to it. My idea would be to include lawyers as part of a mediation process with a mediator. So if people need legal representation, why not, as they do for franchising mediation, the lawyers come into the mediation, but there's a separate, impartial, independent mediator. So the mediator controls the circumstances. Both parties have lawyers, and both parties are advised as they need. They can have intervals if necessary. I can call intervals if necessary, if the lawyers are interfering too much, which sometimes does happen, and slows the process down. So I believe that the lawyers are very important in the process. I work very closely with them, and like I said, I respect the legal industry highly. However, I just think the actual adversarial nature, and it's harmful to the lawyers, it's harmful to the judges. People are making decisions for families, for children's lives, and affecting children's lives when their executive functioning isn't even working properly. And so how can they make these decisions? This is my main concern.
Yes, Senator Hanson.
Thank you very much. You've actually made some comments here about funding and to the family relationship centres due to an inefficient use of funding. Do you believe that we should increase the number of family relationships centres, or should we actually expand it out to other centres to take the workload?
Thank you very much for that question. I believe the family relationship centres existing are not very efficient. They're not being managed efficiently. I only believe that because I have actually worked in them, and I find as a private practitioner, if I worked in that system, I certainly would be going bankrupt myself. So I believe that the funding needs to be there for family dispute resolution and mediators, but why not do it to all mediators across the board and fund per incidence of mediation rather than funding a centre and then they funnel it out in all these different ways and it actually gets wasted, it gets diluted. I've sat in mediations, in a co-mediation, in a family relationship centre where the clients, have a bit of a heated moment or something, and we're only like 20 minutes into the mediation. And the other mediator that had been working at the Family Relationship Centre for 5 years or something, he just called it and said, "Oh, look, it's clear it's not going to work. I'm going to terminate the mediation." And I'm thinking, hang on a minute. These people have had 20 minutes. They've been waiting for months. They're sitting down here, sure. They're not going to get on. There is going to be a little bit of a heated discussion because that's part of the process. However, we can't just quit on them. But see, the family relationship centres, they get paid regardless of whether they actually achieve outcomes or not. And these people working in those centres, they get paid whether they achieve an outcome or not. As a private practitioner, it's interesting the difference, because clearly if you don't achieve things, you won't be getting paid for very long.
I was led to believe it was originally set up that mediation was paid for by the government. Then, under Kevin Rudd, the Labor Party, they actually then changed it so that the second and third mediation, or the third and fourth, is paid for by the people. So therefore, they can't afford to pay for the mediation. Is that true?
Well, family relationship centres fund a small amount depending on how much people have as income. So if you earn enough income, you don't pay. You have to pay anyway. But the second and third, yes, definitely you have to pay more. And generally, more than one mediation is necessary. I've got clients that have been coming back as their child develops from a young baby, because obviously developmental stages change circumstances for parenting. I've got parents that I'm dealing with after over 12 months that have come back at different stages, which is really supportive for them. It's like a therapeutic sort of process where they know they've got a safety net to go to help them make decisions and support network. So
mediation is supposed to be used, and there is a form that they must get, Form 601, is it?
Section 60I.
So they're supposed to get the form, go to mediation, get a form. And even sometimes the judges require them to go to mediation before it becomes before the court system. You made a comment here that it is important to address the issue urgently. Still at the present time, some family law firm websites do not even mention family dispute resolution, mediation, and some lawyers are suggesting to their clients that mediation is usually unsuccessful, influencing parents to use the adversarial process instead. What should be done about that, and should law firms, through regulation or legislation, be forced to actually make sure they have to inform their clients to use mediation?
So two parts to that answer. The first part is, just as an example, I've sat in a social environment where some family lawyers have mocked the system, and they've joked with me, because they're familiar enough with me, about how them and some of their colleagues deliberately use the domestic violence clause so that they don't have to go to mediation. They avoid mediation because of that. And I found that absolutely horrendous, and actually I don't tend to have any social continuance with those people. But a lot of lawyers obviously don't do that, but unfortunately there are people that do take advantage of the system, and they think, well, that's where they're going to get their work from. The thing is, there is a lot of work out there. Lawyers are very important in the process, so we just need to change the process so that it is more effective. The other part to that answer, sorry, I've lost what I was, the other part that I was going to mention about. Sorry, I've lost it right now.
Yeah, I just want to ask you. I've heard from a mediator that the clients have been advised by their lawyers to take out a domestic violence order against the partner so they don't have to go through the mediation process. Is that true?
I'm aware of, yeah, I am aware of that occurring, and clients have told me some similar situations.
We had a hearing with a Miss Mitchell from the Human Rights, denied there is any such thing as parental alienation. Can you explain to me, do you believe there is parental alienation, and how do you see it?
I have specialist training in domestic violence, and I have specialist training in parental alienation. I understand clearly what it involves, and as part of mediation, family mediation, I certainly have witnessed that, particularly on part of the female side, alienation. Whether or not that's, once again, a societal kind of process where the mother regards that she should be in charge of the children because of, societal kind of old school processes, I'm not sure. But I certainly have experienced it within mediation, and I have experienced fathers being completely distressed. Similarly, the gentleman I was mentioning earlier that actually said he was ready to take his own life. And he actually said to me, you saved my life, because if I had waited 4 months for the Family Relationship Centre, he said, I don't think I would have lasted. And he was experiencing parental alienation. The mother was not allowing him to see the child, no apparent reason, but she just said she didn't think he was fit. So there was no actual evidence to say that he wasn't fit. In her determination, he wasn't fit.
I'll leave it to someone else.
Thank you. And could I say, Ms Murdoch, thank you for taking the time to pay for yourself to come up. We do appreciate it, especially in light of the technology troubles we've had today.
Thank you.
I just wanted to clarify, Dispute Management Australia, it sounds like a peak body, but is it your personal business?
It is my business, yeah. So I work as a mediator in family. I work as a mediator in business.
I just want to focus on the family side of things, if that's okay. And have you conducted any mediation outside of family relationship centres?
Yeah, a lot of private.
Family law, private mediation?
Oh, absolutely, 100%, yeah. So I've worked for family
and approximately how many mediations would you say you've conducted?
I would have to check my records, but
just ballpark,
regularly, like I'm doing them regularly. So I'm either working in a mediation as a mediator, family dispute resolution practitioner role, directly.
So outside of relationship centres?
Yeah, my family relationship centre experience was limited. While I was working there, I was actually quite frustrated because I found that the efficiency was very, very low, and I knew the government was paying for it, and that was frustrating me because I don't like wasted money. So I actually decided to do my own private work.
Because your bio says you focus on workplace psychological health and wellbeing and delivering education. But you're saying most of your business is mediation, is it?
Most of my business is definitely mediation, where I actually get my income, yeah.
Okay.
So most of my education is not paid for.
Okay. And so I just wanted to go to the further to Senator Hanson's question about parental alienation, because certainly it's a very contested area. There's some... since it came forward in the 90s, I think, wasn't it? The US psychiatrist to put it forward. Some are suggesting that it's been exposed as junk science, and I just wanted to clarify your expertise in this area. Have you authored any academic papers, or where is your expertise in parental alienation coming from?
Well, I have done specialised training. It is actually also referred to as childhood alignment. So they refer, I think, from the US, parental alienation, that's where the originates from. I'm not sure of the history exactly, but childhood alignment is definitely here.
Well, I just wondered if you could tease out in your mediations, and that's the majority of your work, I think you were saying, how much weight should be given to the strong and clear views of children in these disputes?
Well, obviously, depending on the age, are you asking specifically if we should include the child to be involved?
Well,
as a decision, as a contributor. So, like in the like child consultant role.
Independent lawyer, I think you said you'd had experience with them.
Yeah. So, so the child consultants basically sit with the children, depending on their age. I think they have to be 8 years and above, or it depends. See, this is the problem with the family law system. There's so many variations with all sorts of processes. So there's no consistency. I mean, you go to one centre, you get something completely different than you go to another centre. I mean, some centres actually provide education, which is so important, incredibly important for the families to understand about some of these things.
Ms. Murdoch, going back to that, because I think you said most of your work was on mediation.
Yes.
Income it's private mediation.
Yeah.
Because earlier on you seemed to suggest you had no familiarity with private mediation practices, you know, because in terms of the lawyers actually coming together to work out, to assist the two parties. And I just wonder how would you tell the difference between a parent who is acting protectively, concerned about their child, and a parent that you would say is displaying parental alienation?
There's some pretty clear ways to identify that.
So what would they be?
So, okay, if we're sitting in a mediation and it looks like there is some interaction between the child and the dad. I'll use an example case where the dad was messaging a child and the child was very willing to keep interacting with the dad, but then she knew that the mum was going to be affected, and because she was living mostly with her mum, she didn't want to upset with them. She didn't want to upset.
Was there an order in place for this family, or?
No, there was no orders in place.
So that it was consensual?
I don't know at the moment, because that was some years back. I'm just trying to recall that particular occasion that stood out quite strongly.
No, I just wanted to get that balance between the best interests of the child and protecting the child, which is obviously what the state's most interested in. Yeah. And, you know, good parents, obviously, and this idea of parental alienation. Yeah. So it's in the best interest of the child. I think when I mentioned the basic mathematical equation, when you look at all the problems with adversarial process, and clearly any alienation process or childhood alignment is not in the interest of the child. There's a lot of research that supports that children need both parents, provided that they're safe, they're not being neglected, provided that there's not significant domestic violence. I mean, domestic violence, as you know, is on a spectrum. I mean, there's severe and then there's not so severe. And some of those not so severe cases definitely can still be mediated in a safe environment so that they can achieve better outcomes rather than going through the adversarial process, which will take up to 2 years, you know, that process. So I just wanted to mention one other point. I noticed on the ALRC, one of their recommendations, number 49, building accountability and transparency. This is one that really stood out to me. Firstly, the ALRC, I noted, was heavily weighted by the legal sector, judges, lawyers, etc. I think we need a balanced system because we're dealing with families here. This is a social circumstance, not just a legal adversarial. You do know the Family Law Council hasn't been sat since 2016. It hasn't been constituted.
Well, I know that they made a submission. That's all I'm aware of. So I'm just...
No, but the Family Law Council, I think you referred to in your concern about the ALRC.
Family Council of Australia, Family Law Division. So they have separate divisions. So it's Family Council of Australia, and they have a Family Law Division.
Okay.
And they made a submission, I believe.
All right.
We can ask. All right. Senator O'Sullivan.
I'm a little confused by that last little bit, only because I'm not familiar with enough with the system. But can I just ask, in your report, you do refer to the ALRC's final report on the family law system. It made a number of recommendations, and you say that some of those recommendations you support, but there are a few that you consider are not in the best interests of families and children. To assist the committee, can you please advise which ALRC recommendations you disagree with on the basis that they are not in the best interests of families and children?
Absolutely. So particularly number 49 of the ALRC, Building Accountability.
Family Law Council. Is that the one?
That's the one, Family Council of Australia.
The Family Law Council, which is the Attorney set up to provide a report to the Attorney General each year, and it hasn't sat since 2016.
The family, sorry.
That's...
I think the recommendations, the 60-odd recommendations that were handed down by the ALRC,
Yeah.
that's what you're
That's what I'm
referring to.
referring to.
That's
ALRC.
Australian Law Australian Law Council.
Yeah.
But section 49, I just wanted to be clear, is
Item 49.
Recommendations.
recommendation 49, which is about expanding the Family Law Council's responsibilities.
Yes. Yeah.
And I just wondered if you were aware that the Family Law Council hasn't had any members since 2016.
The Council of Australia, is that what you're referring to?
I'm not sure what that
FCA?
you're referring to.
Can I,
Okay.
can you just go to the, I guess, the principle of the issue with 49 that you've got a particular issue with, rather than
Sure.
not get caught up in which
Yeah.
organisations?
So I've got the actual submission here. So it's the Law Council of Australia, the Family Law section
Yep.
of the Law Council of LCA.
So the principle that you're concerned about?
The point that I'm concerned about is the expanding of the Law Council of Australia, or the Family Law Department of the Law Council of Australia, expanding their responsibilities. Now, the reason why I'm concerned about that is, as I mentioned earlier, law is fundamentally a win-loss game, and this is still deeply entrenched with the profession. We're dealing with families here. So this is a social circumstance. If the Law Council of Australia, LCA, Family Law Department or other...
LRC refers to the Family Law Council. I just want to be clear.
Is that what they refer to?
Thing. Yeah.
LCA, though?
The Australian Law Reform Commission, in their report, referred to the Family Law Council.
Okay. Well, all I know is the Law Council of Australia has made a submission to the ALRC. And it's number 49 that I'm concerned about.
For clarification, what I understand you to be saying is that there is some part of the Family Law Council submission to the ALRC that you disagree with, and what you have in your hand is the Family Law Council's submission. So could you identify what part of that you disagree with? That might help us all.
Well, it's actually the ALRC recommendation, number 49 that I'm concerned about, in whole.
And so you disagree with recommendation 49, and you therefore disagree with the recommendation from the Family Law Council, which supports recommendation 49.
I believe they would support number 49. Yeah, I believe that they have supported that. Yeah. Right. However, I do support the Law Council of Australia in many of the other.
Yeah, sure. We were just trying to,
yeah.
I think we were just confused about what it was that you're agreeing or disagreeing with. Yes, Senator O'Sullivan.
Thank you for clarifying.
And so, are there parts that you strongly do agree with?
Yeah. So, mentioning increasing awareness of domestic violence, very important. Education, very important. Trying to get like a systematic process, lessening the adversarial process, and all those things that I mentioned earlier that are problematic here and now. So the long waiting process, the 2-year, however you want to call that, up to court, and then they outside of the door of court settle in a lot of cases. So sure, they don't make it to court, 95% or more, but they go through the process of the court process. So that's very concerning. So
Recommendation 21 goes to asking or requiring demonstration of the parties have taken reasonable steps to address, to try to resolve these issues outside of the courts.
Yeah.
Do you have a particular view on that? And what do you think the demonstrated genuine steps should be?
Well, the problem is that comes up a lot. If it's not in parents benefit to mediate, they won't make a genuine effort. So basically, if they don't want to mediate, if they don't want to solve it, if they want to actually keep the child, in alienation cases actually this happens, if they would rather just keep things as they are, then they don't want to mediate. They have no reason to mediate. It's the other party that's suffering, the other parent that's not getting access to the child. So they don't want to mediate, so they won't make a genuine effort. And this has definitely happened in my private cases.
So how would you require that, do you think?
How would we...
How would we... If we were to, create a new
well, firstly...
procedure here, what would it need to look like?
Yeah, so firstly, the law says that they're required to make a genuine effort, but then there's no consequences if they don't. So the Section 60I certificate can be issued, and there's a different number of reasons why it's issued. Firstly, I'm aware, and I believe the Attorney General's Department is aware, that the Section I certificate, there's certain boxes on there. If you tick the truth, and that is that a party has not made a genuine effort, you're more inclined to get a complaint made against you, and they're correlated. So people avoid telling the truth because they know that they're going to get attacked over that. And I've been stalked myself in a case where a mother was very upset because I said you're not making a genuine effort that's in my professional experience, and that's because she just kept avoiding. She didn't want to attend mediation. So, and meanwhile, the child was not seeing her dad. So we weren't getting any resolve. So I believe there needs to be consequences, and the judge, I believe, has power to award costs against the party if they're not making a genuine effort. However, I don't know that that's ever happened. I'd be interested if anyone knows if that's ever happened. And the other thing that parents make a mock of the court is that in breach, I've had women who are comfortable enough with me, parents that have told me that they breach left, right, centre, and the fathers as well. So I'm not sticking with one or the other here, let me tell you. I'm just saying that people take advantage of the system, they manipulate the system, and we need to put in processes that's going to help resist that, because people are well aware how they can manipulate the system. It's kind of like a criminal, like always trying to keep up with how to actually stop them from doing what they do, and then they invent a new way to get away with what they're doing. So with regard to the genuine effort, there needs to be consequences, and they need to know, it has to happen for people and their lawyers to recommend that's going to give you a consequence if you don't make a genuine effort.
Okay, thanks.
Thank you, Chair. Thank you, Ms Murdoch, for coming up today, and I appreciate your commitment.
Thank you.
And your sincerity and your experience and your courage in just saying what you have experienced.
Thank you.
I want to build further on the Chair's question about the adversarial nature of family law system. You come out very clearly saying that it is counterproductive. Perhaps what I want to do is go to a step further and say, are you aware that systems drive behaviour?
Yes, I am.
Okay, thank you. And we've seen systems like the law system, random breath testing has changed dramatically the attitude towards driving under the influence of alcohol over the last 30, 40 years. And various systems, tax systems, drive behaviour, and they change the attitudes. Now, in addition to the systems driving counterproductive behaviours, which is what you just said a couple of minutes ago, in addition to that, within this family law system and process, we've got very, very strong motives, because there's nothing more important to a parent, both male and female, than their child and having access to their child. And so we've gone a system that drives counterproductive behaviours, as you've said, and dishonest behaviours. You lump that in with the motives of getting access to that child and sometimes trying to control that child. It's a recipe for disaster. Is that right?
In some cases, definitely, yeah. And, I might add, money is another driving factor. By the way, property disputes, I believe, should be mediation mandatory.
Could you expand about the money? You're not talking about settlement of divorce cases. You're talking about money within the family law system driving behaviours?
Well, if I could quote another practitioner that said to me early on when I worked at a family relationship centre, I made the comment, which I don't 100% agree with, but, she said that, let's face it, guys use money to manipulate the family's outcome. Women use their children. And I remember thinking about that and thinking, okay, every now and again I see that. It's not there all the time, obviously. And solicitors, barristers, I've heard all say similar sort of things, how the family law system there's definitely people out there that are manipulating the system.
Are there too many ways to make money out of the family law system without settling it, actually prolonging disputes to make more money?
There are people making a lot of money out of people's disputes.
Just a question about violence. You mentioned violence perpetrated by both genders.
Mm-hmm.
There's physical violence and there's also emotional violence.
Oh.
And are DVOs being used as weapons as one party seeks to gain advantage in the proceedings that are already convoluted and complex?
So as you'd be aware, coercive control is domestic violence. It doesn't mean that you're getting hit. You don't need to get hit because you know where your line is. So there's so many various forms of domestic violence, some of which are more related, as per some of the training that I've done, some are more related to long-term serious violence, serious outcomes. Coercive control, as far as I'm aware from my training, is one of those. So that doesn't require physical harm.
Yeah. And what about DVOs? Are they used as weapons within the family law system to gain advantage from one party or the other?
Well, unfortunately, as I mentioned earlier, I have heard people solicitors talk about the fact that some of their colleagues use the domestic violence exemption so that they don't have to go to mediation, so they go through the process of the court.
So sometimes there's a race to get the VO in on the other person?
Sometimes I believe that some people and some people working in the legal system use it. Not only in the mediation, but in discussions, overall. Just in general discussions, not mediation. I mean, I've certainly had clients tell me that as well. But aside from that, I've had solicitors tell me that, and they mock the system. It's embarrassing. I'm ashamed sometimes. I feel like that's disgusting.
Ms. Degel or Senator Walters, got any questions?
Sorry, Chair, I had a question. Zoe Degel here.
Yes, go ahead.
I just wanted to I'm a little concerned at some of the generalisations in your evidence because this is a highly factual jurisdiction, and so it is really important that we're not. So your comments, are they in relation to, like you were just referring to comments that someone making to you? Can you give us any more information about sort of numbers, statistics of your experience, cases, experience, and then the breakdown of where you say, abuse of the system or disregard of the system, stand and put in perspective?
There was a mediation conference about 3 or 4 years ago that I can't recall the name of the actual workshop, but it was discussed the incidents of where up to 50% of cases were not even referred to mediation. And I did ask the question, why would that be? And then there were a number of different reasons, and one of them at the time was indicated that domestic violence was mostly to do with the reasons why they don't go to mediation.
I guess if I could, Chair, just request, I mean, if we could get that on notice, that you could provide maybe the details of that conference. And I just think it's just dangerous to make...
Tell the truth. I'm telling the truth.
Sort of generalisations without, I guess, the substantive...
I'm not making generalisations. I'm just telling the truth of what's happening out there. I'm on the ground. I'm seeing what's happening.
So these are your actual
mediation. That's why I'm asking you to quantify it. So in terms of, for example, of how many cases you've been involved with and what percentage of those cases, for example, fall in that category.
So in some cases, I'm actually at a conference where it's being discussed. So I'm not in the mediation. I'm at a mediation conference.
So this is secondary sort of referred information to you. It's not your personal experience.
It's official training for mediators and lawyers, so I'm not sure how you'd like to take that.
I guess I'm interested in your personal experience rather than it being referred to or something that you've heard at a conference
Sure.
from others.
Well, I have referred to some
to
of...
get to the bottom of specific numbers or specific sort of experience that you personally have had.
Does it matter how many numbers? If it's happening, isn't that something we should look at? If it's happening to one child, family, where there is deliberate childhood alignment or there's deliberate manipulation of the system, if it's happening to one child and that harms that child long term, which it does, all the research shows that it does, isn't that enough? Isn't one child enough to be harmed? Why do we have to have numbers? I've given you some of my examples. I can list down a number of examples if you wish, but in my mind, one child, two child, 10 families, 50 families, I'm sorry, I just think it's not acceptable for children, and I believe that's why they're suffering the way they are. They're growing up angry, they're growing up aggressive, depressed, they're cutting. One of my 12-year-old clients' children is cutting themselves. They lost a scholarship. They were a state championship at a private school. They lost their scholarship because they were so they couldn't regulate their emotions. They were jumping fences from the school. You know, I mean, I see these things. I'm on the ground seeing these things firsthand, and it's heartbreaking because I know how much harm is happening to children. And I'm not saying that it's anyone's fault. I'm just trying to say that I'm seeing these things happening, and we need to do something about it, and we need to reduce the conflict, the ongoing, relentless conflict. It's not good for anyone, for the children, for the parents. It's not good for the family lawyers. It's not good for the judges. They can't make clear decisions when they're under chronic stress. There's a lot of research out there on that as well. How can we make decisions? How can parents make decisions? Of course they're not going to. You know, when I have clients sitting there saying, oh, you know, I'm sorry I'm reacting like this, and I say to them, of course you're reacting like this. You're going through this serious family separation. Of course you're going to have a reactive style. You're going to be distressed. That's normal. In fact, if you don't have it, you'd be questioning why you don't, because only sociopaths don't have some sort of reaction to stressful events like this, especially family-related. And that's why I think this is a social environment. We need to have a balanced social outcome for this. It's not adversarial. That's not going to make the best outcome for the interests of the child or the family.
Thank you.
One of the other recommendations by the ALRC, and I don't have the number here, was to actually do away with 50-50 custody. So it is in recommendations under the legislation, but it's at the judge's discretion. What's your opinion on that?
So as far as I'm aware, we don't refer in Australia to custody necessarily in the legal system. We refer to shared care. And the idea of shared care is that we have significant and substantial time, because it's in the best interests of children to have relationships with their parents, and that's significant and substantial time. So we're talking mixed time, not just fun time. So not just once a fortnight with dad going to Dreamworld or something. He's actually, you know, being involved in the child's life, whether that might be homework or food or, you know, whatever extracurricular activities during the week as well as the weekend activities. So mixed is very important for both. I mean, I'm a mum, and I dearly love my children, clearly, and I understand, you know, how you feel like you want to protect them, but it is really important that people are educated in that the balance, the outcome of how they need both parents, provided there's not significant domestic violence harm. And by the way, significant domestic violence, usually there is a long-standing history. There's usually, it doesn't just come out of the blue all of a sudden, usually. There are episodes of that. There's different kinds of domestic violence, but usually there is some sort of track record, whether that's controlling behaviours or other. isolation. You know, I just think that sometimes we need to look at the big picture and see that, sure, there may have been incidents of domestic violence. What actually is involved here from both sides? Because usually, I've certainly had the experience in mediation, both sides have committed some sort of domestic violence. I'll give you an example. I do a safety checklist, and I did the mum safety checklist after the dad, and I said to her, has he ever hit you, kicked you, used a weapon, blah, blah, blah. I go through this range. And she's, no. And then have you ever hit, kicked, used a weapon, blah, blah, blah. No. And then she said, well, he did try to strangle me once. And I said, whoa, okay. So as soon as I hear something like that, so tell me more about this. And then she said, well, because I said, what led up to this? Tell me exactly what happened, you know, trying to get a big picture. She said, well, I did pull a knife on him. And I thought to myself, I've just asked you if you've used weapons, but these people, I don't know whether they've got blinkers on or, like I say, they can't think straight when they're under chronic stress. So this is what we need to really address, is lessening that. And I noticed vicarious trauma was brought up also in one of the FCA submissions, vicarious trauma. I think that anyone working in the legal industry needs vicarious trauma training. Absolutely essential, because we're all affected by it, and we actually, if we're in a position where we're impaired, our functioning is impaired, how can we possibly help parents that are not functioning properly? They're in the chronic high stress zone.
Just one last question. Do you believe that due to parents, whether it be their father or the mother, not seeing their children for long periods of time actually cause domestic violence, stress, and also suicide?
Well, I can relate to the gentleman that said to me that he would have probably committed suicide had he not have been able to contact someone. And I just happened to be that someone. He looked me up under Attorney General's website as an accredited mediator, a family dispute resolution practitioner. He rang me. I think I was in Melbourne or Sydney at a conference, one of the training conferences. I may have actually been providing the conference or attending a conference, I can't recall. But I said to him, I'm in Melbourne or Sydney, and I said, but I'm back, you know, in the next 2 days or something, and I can see you then. And yeah, he definitely made a very clear declaration that was the case. And yeah, sent me, you know, emails saying thank you so much, you saved my life. So I'm not sure if that answers your question, but that's one example. There's many other examples of similar sort of cases where people are, once again, chronically distressed under circumstances. So any kind of chronic stress will actually create people to go into a primitive part of their brain, and they will react in ways as if they're being attacked by, like, a tiger. So if we're going to be that reactive when we're under chronic stress, then clearly we need to actually lessen that stress. And I believe the adversarial system, the long waits, all the rest that I listed before, I believe that's where the key is to trying to solve that problem.
One final short question from Senator Roberts.
No question, Chair. I just wanted to put on record that you mentioned, Ms Murdoch, meeting people's needs has to be the core focus, and that is entirely in alignment with the work of Marshall Rosenberg, nonviolent communication. So I just wanted to not only put it on record but compliment you for that, because that has to be the focus.
Thank you. When I sit in mediation, I always say to the parents, I work in the child's interest, the child's best interests. So I'm impartial to either party. I'm not in favour of either party. However, I am very clear in understanding that whatever affects the parents affects the child. So as soon as you create more problems for the parents, the child's going to suffer. One way or another, whether it's indirect or direct, they might not even know it's happening. A lot of it's unconscious, actually. We don't mean to hurt them, but that's what happens when a lot of pressure.
I'm afraid, Ms Murdoch, we're out of time, so can I thank you again for your submission and in coming along here to Townsville to discuss it with us. We appreciate that. There may be some questions that committee members have that we haven't been able to get to. If we could forward to them to you on notice, we'd appreciate if you're able to respond to it. But thank you very much.
Thank you. I hope you look after our families and our children. This is such an important area. I really think that everyone really needs to
Thank you.
put
Thank you.
100% effort into this.
Thank you.
Thank you.
Now, have we got the next? I believe we have the representatives of the Queensland Law Society online.